Hello, my name is Mark DiCarlo. Tonight my guest is Mr. Michael Gordon, longtime Assistant District Attorney in Nueces County. How many years?
About 11 years now.
So how many administrations did you cover? How many DAs?
Let's see. I started with Mark Skirka, then Ana Jimenez. I'm sorry, I started with Carlos Valdez.
Okay,
then,
right, Carlos.
Then
right.
Ana Jimenez, then Mark Skirka, and now Mark Gonzalez.
Well, maybe you'll run someday.
Don't
Just
count on
teasing
it.
you. Just teasing. I don't know how all that works. I don't know how all it works, but yeah, I remember all of them. And before Carlos, of course, it was Grant Jones. That was when Grant Jones was when I started.
Yeah, when I got here to Corpus Christi and started practicing law, I wasn't practicing criminal law, but that's Grant Jones was the incumbent DA then.
What year did you get here?
1984.
Yeah, I got here December of '85, so we're almost right on point. At any rate, you did criminal defense work too for a while, correct?
Yes, I did big law firms for about, I don't know, roughly about 10 years, then sole practice for about 10 years, and then went in with the DA. When I was in sole practice, I found that criminal became more and more a part of my practice to the point where by the time I went to work at the DA's office, it was just about full time.
So when you would say big firm law, did you do insurance defense?
Yes.
Oh, that's interesting. I used to do a lot of personal injury before I got kind of undercut by the massive advertisers. So now it's no longer a third of my practice. It's a lot less than it used to be.
I can imagine.
You know, so that kind of killed me. So what do you think of the difference between doing insurance defense work and criminal law? Now, in insurance defense, you would have all your cases would have been in litigation, right?
Yes.
So you did a lot of discovery, you did a lot of questions called interrogatories, and a lot of depositions under oath, correct?
Oh, yeah.
But you don't really do that. You don't really do much of that in prosecuting criminal cases.
No, in 11 years as a prosecutor, I haven't taken one deposition. Yeah, I mean, it is there in the rules. You can do it, but it requires, there's lots of requirements you have to go through first, and it just isn't done. Sometimes I wish we did.
Well, see, the amount of money that is involved.
Absolutely.
Is so, I was telling someone the other day, if I practice in federal court, and the amount of money the feds have to prosecute and pursue a case is just unbelievable.
Sure, but they basically, at least from the outside looking in, it appears their resources are unlimited.
The resources are virtually unlimited.
Yeah.
I have a case right now. Every time I've been to federal court, they've had 3 federal prosecutors against me. 3 of them. And now that in per se isn't a big deal, but it's just indicative of the kind of money that they have.
Sure.
So it's a big difference. And I know I practice over there in obviously do criminal defense. As a matter of fact, you and I almost went to trial. Was that about a year and a half ago? Remember, an assault case?
Yeah, I do vaguely remember.
It was in a car wash, remember? Fight?
Oh, I do remember that.
Yeah.
Yes.
Yeah, we spent some time. We worked it out.
We worked it out.
At the very end.
Like just on the morning of trial, I think, didn't we?
Yeah, yes. How often does that happen where you work something out the morning of trial? Fairly often, right?
Oh, yeah. Quite often.
And
you and I tried one.
Many years. Yeah,
Many years ago.
That was maybe 6 years ago. And you won.
That was right when
I don't know. You must be very skilled to... I'm just teasing. No.
I think we as lawyers give ourselves way too much credit for whether we win or lose cases. I think it has a lot more to do with the evidence than it does
and
the lawyering.
Evidence and the facts. Well, that was an assault case, and you never know what you may have a criminal defendant that wants to take the stand and kind of speaks irrationally or belligerently. You probably have that happen on your side too, right?
Oh, yeah.
So you don't count on that, and they may be even perfectly rational in your office, and then the day of trial they start saying.
Well, then the day of trial they get up there and there's a judge and 12 jurors looking at them. When I was a criminal defense lawyer, I strongly discouraged clients from testifying. Very rarely can you help yourself. Well,
I've had the opposite experience. I've had almost in every criminal trial I've tried, the defendant would testify. And from my experience, I've had success with it, except in one kind of case that I don't want to go into today, or in the the defendants are a little bit strange. I won't go
Okay.
into. I won't go into.
Well, I mean, juries want to hear that. They want to hear
do.
the guy look at him and say, "I didn't do this."
Yes.
But so often they've got the kind of criminal history that your prosecutor's going to be
Well,
sitting there licking his or her chops and saying,
Well, that's true. I haven't done court appointments in many years, so therefore many of my clients don't have that criminal history where you could say, well, you say you're not guilty of this theft, but weren't you convicted of a theft 5 years ago and 10 years ago? You know,
Exactly.
I'm sure. Yeah, that's a tough gig to win when that occurs. And so you worked in many administrations. You want to say who was the best DA? I'm just kidding. You don't have to do that. I'm just kidding. But Mark Gonzalez has been over there, about 6 months or so?
Yeah, we're coming up on 6 months.
We were talking before the show that you were having some problems. I guess you have openings. So people like me that need jobs, maybe we could go over there and interview
Come talk to us.
the assistant DAs.
No, we are understaffed because a lot of people did leave at the end of last year before Mark took office. Mm-hmm. And we're busy interviewing and bringing people in.
So Mark DiCarlo wants to go over there and get a job as assistant DA. What's the job pay me? Do you know?
Somebody asked me that question just a couple of days ago, and I'm not sure what the starting salary is. A lot of it depends, I guess, on your experience, on what level they plug you in at an attorney 1, attorney 2, attorney 3, and so on.
I think it's too low.
It is. Yeah, we're about 20-25% behind comparable counties as far as our pay. I think maybe it's in the high 40s for a beginning lawyer, but
Excuse me.
I would. Okay.
Well, I think some of these towns around here, Kingsville, Alice, Sinton, they all pay more money,
Oh yeah.
and they're smaller.
Well, and until we get paid what lawyers are getting paid in comparable counties, we're going to continue to be a farm team for other offices.
What do you mean by that?
That means lawyers sign on to work here in Nueces County. They get trained, they learn to try cases, and then they go somewhere else for more money. And it makes it hard to keep experienced prosecutors.
Years ago, I paid my secretaries less. And I was having such a high turnover, I said, I'm either going to have to pay more money or I'm going to have to go out of business. Whether or not I think I could afford it or not. Because the turnover will kill you, in terms of trying to run your office. So I'm assuming the district attorney, it's up to them to lobby the county for better pay. And I'm pretty conservative fiscally. But I do think some of the prior DAs should have done a better job in lobbying for higher pay for the assistant district attorneys.
No argument.
That's my opinion.
And in fairness, they did, but they just,
they did?
Yeah, and we would get raises now and then, but overall, nobody's ever been able to get us close to what the market is.
Well, my opinion, there's a transaction cost whenever you get someone in new, so it's not as efficient as what they might be thinking.
Absolutely.
To pay the low wages.
Yeah, well, and it means that our average years of experience stays way down, because as soon as people become good courtroom prosecutors, it's time for them to move on and get paid somewhere else, and we're back to having lawyers straight out of law school.
Something new has changed. We've discussed on the show before something called the Morton Act. The Morton Act, I could sum it up, and you can correct me if I'm wrong, is basically a rule that says that the prosecutor, the district attorney's office, has to give the criminal defense lawyer, the criminal defendant, all the evidence. Is that correct?
Correct. Well, that's always been the rule. It's called, we call it the Brady versus Maryland. I'm sure we refer to it shorthandedly as Brady material. Anything that tends to mitigate guilt, we are required to turn over to the other side. And what the Michael Morton Act did is just strengthen the enforcement of that rule by enhancing penalties and consequences. And it came out of I'm sure you already know this, but it came out of a case, a guy named Michael Morton, who spent, I think, 20-something years in prison for a murder that in the end it became very apparent he didn't commit. And the prosecutor in that case, Ken Anderson, pretty blatantly hid evidence. It didn't turn stuff over that was highly exculpatory. And even after it became apparent that that was where this case was going, he and his then boss, and I don't remember who the boss was, he was the DA there in Williamson County, continued to fight it. And that's what brought this to a head. It's why Ken Anderson is no longer, by that time he was a judge, but he's no longer a judge. He's not even a lawyer anymore. He's now been convicted. And I don't remember I can't remember who the DA was then. Maybe John Bradley. But in any case, I know he was swept out of office in the next election, and the voters of Williamson County decided they'd had enough. And I don't know what he's doing now.
That's interesting. That was Williamson County?
Yes, just north of Travis County.
Okay, I had a pretty big case up there on appeal or something one time. That's interesting. I'd read about the fact scenario that you said about, but I'd forgotten that it was Williamson County. I was in court, one of the smaller towns, local towns, and they actually they have like a checklist for the defense attorney to sign off on that they introduce into evidence that there's been total compliance with the Morton Act, but I haven't seen that in Nueces County.
That's in our plea papers.
Is it?
Yep.
But that's more like a signature. This is more specific on actually a check mark of
Oh, I see
everything
what you're
received.
saying.
Yeah.
Yeah, it's not a bad idea. Now, when we take a case to a jury trial, there's a packet that we put in the court's file,
Right.
which is a copy of everything that has been given to the defense, and both the prosecutor, the defense attorney, and the client sign off on it. And then we put that into evidence before we start picking a jury.
The other side of the Morton Act that's made it more difficult, we had more freedom back years ago. You remember when the Victims' Rights, were you practicing before the Victims' Rights Acts took place? Were you practicing criminal law?
Probably not. I don't remember
Okay.
exactly when the Victims Act.
Well, I think it was longer ago.
Yeah.
But it used to be we'd go in there and hammer out a deal with the prosecutor, the defense attorneys. Now we can't just do that as much. They got to, the prosecutor say, well, I got to check with the victim. I got to see if it's all right with the victim, etc. Made it much more difficult for the prosecution.
Well, I suppose it does, but number one, and you're required to do it, and number two, I think it's the right thing to do anyway.
Do you?
While our client is not the victim, our client is the people of the state of Texas.
That's right.
It is this community. Nevertheless, the victim does have does and should have a role in expressing their wishes, and doesn't mean we're completely bound by what they want. But I can tell you personally, I take what the victims want very seriously. And as long as it's within the realm of what is reasonable, I try very hard to get them what they want.
But it puts you in kind of an interesting position. Do you ever have to tell, I'm sure you would have to tell the victim at some time, the alleged victim or the victim, you'd have to say sometimes, look, I don't think I could get a conviction on this case. You'd be better off if he got probation, because at least then there'd be some guidance. If you go to trial and we lose, then there'd be no punishment whatsoever. Are you ever in that position?
Every week.
Every week?
Yeah. And it's not always telling them what they want to hear. Sometimes you've got to give them this, and I think you give it to them straight. It's, trials are not about what we believe or even about what we know. Trials are about what we can prove. And sometimes, for whatever reason, I think, the evidence is either not there, or for whatever reason, I'm not going to be able to get this evidence, in before the court. And you have to tell the victim, I don't like our chances at trial. And we stand a good chance of walking away from this empty-handed. And we better just give this guy probation. And, if he gets it right, great, everybody wins. If he doesn't, well, then it's on him.
I'm going to ask you something off point that isn't unfair, because, again, this show is extemporaneous. You don't know the questions. I wonder, what is a percentage of people that successfully complete probation?
That's a real good question. I would defer to any probation officer.
Right? Maybe we need to have the probation department on that.
I would think maybe, of course, it's hard for me to say, because the only ones I see are the ones that screw it up, that come back to court on motions to revoke their probation.
Right.
So that sort of skews my viewpoint on it. My guess would be probably 20-30% skate through probation, get everything right, do it perfectly,
Mm-hmm.
and maybe the next 50% have some bumps along the way, maybe get sanctioned, but they eventually
Mm-hmm.
get through, and then whatever's left are the ones that don't make it and get revoked.
Sounds pretty close to what I would guess, in 10 percentage points or so. Yeah, it'd be hard to say.
Yeah, and I'm pulling those numbers out of the air, but that's just
Right, just
the gut
based upon
feeling.
your personal experience. Are you doing motions to revoke now? You were telling me before the show. I'll go backwards. What kind of cases are you doing right now in Nueces County?
Okay, I am still the senior prosecutor in the 28th District Court. That's Judge Hassett.
Mm-hmm.
I have also, since the Gonzalez administration took over, I've been made the chief of misdemeanor courts. And the reason I'm still doing both jobs is we just don't have anybody to replace me in the 28th yet. And as soon as somebody is available, then I'll get relieved of that duty and be full-time chief of misdemeanors.
But it would seem like your trial. I was talking to someone because I only tried one case against you, and it's always hard to formulate how good someone is or whatever. But I was speaking to someone about you the other day, and they gave you a compliment, said you were a very good trial attorney, and I was just saying, well, I tried one case against him. I don't remember that well. So it seemed like your experience would be well used in trial, though, correct?
Well, yes, but at the same time, it can be used to teach the new lawyers. And most of the lawyers in misdemeanor courts come to us straight from law school or with very little experience. There are exceptions, but as a general rule, and of course we have a chief of training now, that's Jenny Dorsey, but that's still part of my job as chief of misdemeanors is to help bring those lawyers along.
I see. So that's interesting. Are you going to be trying any misdemeanor cases, or are you just going to be? Are you going to be trying any misdemeanor cases?
No, my method is with the young lawyers is, the first one I try, you sit here with me and you watch. The second one, you try it and I sit here with you and you watch, and I watch, and then I push you out of the nest. And
well, for whatever my opinion's worth, I would think that'd be one of the best ways to do it.
yeah, I think so. I mean, you can only learn so much by watching somebody else do it. At some point, you got to do it yourself.
Yeah, I would think that'd be very, very effective. And how do you like trying those DWIs? Aren't those the most boring cases? No, I'm just joking.
Actually, just because that's such an area of
so
law.
boring. Yeah, I'm sorry.
But no, it's an area of law that the law is constantly changing, and there's we've got the all the rules about mandatory blood draws now, and what you have to do to get a mandatory blood draw, and when you can get that into evidence. So it tends to stay right there on the cutting edge, and that keeps it interesting.
Yeah, I've never really liked trying DWIs myself, but you are right. The law does change a lot. The good thing about trying them, especially a first-time DWI, my clients are all retained, right? I don't get court appointments, so first-time DWI. A lot of times my clients don't want to pay to do a DWI trial, even though I say, well, there's no downside, really. You get probation unless there's an accident or something.
If you haven't hurt anybody, it's your first brush with the law,
well go to
you're
trial.
almost certainly going to get probation.
Anyway.
So you've got nothing to lose by going to
Nothing
trial.
to lose except for your time, except for your time and the money if you have to pay your own lawyer. So, that could be a difference. I never heard this said before, but I was going to a trial in a smaller town around here recently, and I was telling the client, I said, well, they said you got to go to jail for 3 days to get probation. I said, you'll be in trial. You'll be in trial a day and a half. That's almost like being in jail, right? I mean, you got to be there.
You got to be there. You're at the mercy of the judge,
right? I mean, you're in the courtroom. I said, I don't know. I said, maybe you should do the 3 days instead of going to trial.
What I've heard some lawyers do, and if I ever find myself back in private practice, I'm going to think pretty seriously about this. Is for DWI cases, they charge the same fee whether you try the case or not.
Right.
And the thinking is, I don't want you making, Mr. Client, your decision about whether or not to go to trial on money. I want you making the decision based on the evidence, the facts in your case.
But they'll all go to trial then. That's the problem. I mean,
Probably.
That's the problem. They'll all go to trial, and a lot of them aren't triable cases. So I don't know.
Yeah.
I mean, it's six. I think I was the first one that I knew of that did the staggered fee. That way, they would have an incentive to do the plea.
Sure.
And it is a complicated thing.
Well, I guess the only catch there is you run the risk as a defendant if you have just a blatant case, where there's just no doubt about guilt, and you insist on trying it anyway. You take the risk of annoying a jury to the point where they might give you time just to make the point.
Well, you go to judge for punishment then.
That's the
Generally on the misdemeanors, DWI, I think I go to the judge for punishment because
Yeah, they mostly do. Every now and then I'll see a case go to the jury, but you're right. In most cases,
Actually, interesting point. Are you aware of the fact that in many states you can't really go to the jury for punishment?
Oh yeah. In fact, when I'm selecting a jury, that's one of the things I point out is that Texas is one of the few jurisdictions where defendants have the option of having a jury assess their punishment if they are convicted, and that's kind of how I start off to the voir dire about punishment.
That's a questioning of the jury panel, the voir dire, and
right.
It gives the defendant a lot more options and a lot more leeway.
Sure.
Some years ago, I had tried a case on a young man that was drinking, and at any rate, we pled guilty to the jury, and the jury did give him probation, even though it was a pretty kind of a bad crime. They thought him as young and clean cut, and he got drunk.
I did that. I talked a client into doing that one time as a defense attorney, and it worked well.
It could work
in
well.
her case, it was, look, there's just no doubt about your guilt. It was failure to stop and render aid after an accident.
Yes.
And I said, look, there's really no defense to this.
Right.
Why don't we, instead of just trying the guilt part of this, go ahead and tell the jury in so many words, look, I'm here to take my medicine. I just want a fair dose. So let's plead guilty to the jury, and then tell them, put on our mitigating evidence as far as punishment, and then let them make the decision. And it worked well.
Yeah. I only recall offhand doing it once on a major case, and it worked well too.
Yeah, I'm surprised that defendants don't take advantage of that strategy more often than they do.
Well, I don't know. I don't know that the facts, situations, do they come up that often where you would want to do it? My particular case, the bar that my client robbed actually was serving him liquor, and he was underage. So it was interesting. Mm-hmm. So my client was getting drunk in this bar, and he was underage. They were serving him liquor illegally, and then he robbed the bar. And I said, look, and he was a pretty clean-cut young guy. I said, well, look, you can't be,
He was 18 years old.
He was
drunk
18.
and acting like a stupid drunk 18-year-old.
Yeah, at 18 years old. They're the ones that got him drunk. So that was some years ago. We're always hearing talk about illegals, and because I do the federal court cases, it occasionally comes up more there. But you get many illegals that are actually, you go before the judge and you say, well, he's illegal. Does that happen much in Oasis County that you see?
Not that much. I mean, of course, we don't prosecute people for being here illegally. That's up to the feds to do that. But
of course,
it's still part of the litany on pleas to ask the defendant, are you a citizen? And if the answer is no, then there's some particular warnings and admonishments that have to be given to them, such as, you understand that a plea or a jury finding of guilty can affect your rights to apply for citizenship. And it could lead to your deportation and things like that. I don't see a whole lot of that, just because probably 95, maybe something north of 95% of the time, when the judge asks somebody, are you an American citizen, the answer is yes.
Yeah, I was bringing up the point because a lot of people think we have all these illegals here committing crimes. I don't see it very often. I think I had one maybe 6 months ago who was not a citizen, and there was some issue regarding if he pled guilty, would he be deported? And obviously, if you're a criminal defense attorney, it brings up some problems too, because we're not immigration lawyers, and then they deport you for some crimes and not for others, etc.
We're talking about two different things. I was talking about cases where people are actually here illegally. Now, when people are here legally, but they commit a crime,
well, that's
another deal. Yeah,
that's true. I was kind of mixing them up. You're right. So there's an issue regarding whether or not you're here legally, and it's going to result in your deportation, versus if you're here illegally.
Now that comes up, I don't know, maybe 10, 15% of my cases, we have, people are here they're here legally, but
papers.
But if they either plead guilty or are found guilty, there are going to be or could be immigration consequences, and sometimes that causes them to say, I got nothing to lose. Let's go to trial and hope for the best.
Right. Well, let's assume that somebody's here legally.
Legally. Okay.
Well, legally, but they're not a United States citizen, and they go to trial, and they're found guilty, and they're in jail. Do the feds come pick them up? Do you know? Do they transfer? Does the jail have a system where, look, he's illegal, he's legal, but do they notify?
That's a good question. I don't really know how that happens. Of course, if they're here legally, they are presumably already in touch with the immigration authorities. I mean, they had to apply to get a green card, so I would presume there's some sort of periodic check-in or something like that. I don't know. I mean, we don't pick up the phone and call the feds and say,
I know. A lot of times we don't follow up. There's certain things when our cases are over, even on the defense end. I mean, they're over.
Right, and
I can't.
And I'm not going to call up the feds and say, hey, I just got so and so convicted today of robbery. Y'all may want to come check him out.
This is an unfair question in a way, but under the last presidential election, there was some Donald Trump, now president, made implications that illegals were committing a lot of crimes, in the United States. Have you found that to be the case locally, or have you noticed that?
Honestly, I don't think so. I mean, I don't think there's any, enhanced criminality to the portion of our population that is here illegally. My thinking is they probably commit crimes at the same rate that legal citizens commit crimes. There's a portion of people who are going to behave that way, but the vast majority do not. And I doubt the percentage is much different from those of us who are, citizens.
Yeah, I can't remember the last time I had an actual illegal in state court. I had one in federal court maybe a year and a half ago. But actually, he didn't commit a crime. He just came back over illegally.
Right, which is a federal crime.
But
yeah, it's a federal crime, not a state crime.
Right. So, I guess if this area is any indication in the surrounding areas, I guess illegals aren't doing a lot of crime that I could see.
No, and when I talk about the plea process where the judge says, "Are you a citizen?" The judge doesn't ask, "Are you here?" Doesn't follow up the question if they say no with "Are you here legally or illegally?" They don't ask that. The question is just, "Are you a citizen?" And the answer is yes or no. And whatever your immigration status is beyond that, they don't ask them that.
No, I think it is good that they ask. And as you're stating, we only take it so far at the time of the plea.
Well, if you ask somebody, "Are you a citizen?" and they say no, if the follow-up question is, "Are you here illegally?" you are violating their Fifth Amendment.
That's interesting.
Because basically they are admitting to a federal crime, which is being here illegally.
So you've been doing the manager train. What did you term it? I don't know. Manager trainee. It's not McDonald's.
No.
You're training the misdemeanor prosecutors.
That's part of my job. Yes.
What is the percentage of cases over there that are misdemeanor that are DWIs?
Of the misdemeanor
Yes.
caseload, I would guess probably 30, maybe 40%, and then the rest, everything else:
Assaults, thefts,
all that kind of stuff. A lot of driving while license expired or driving while license invalid.
So if I want to get out of a DWI, what should I do? Just joking. Just joking.
Don't drink and drive. That's the best way.
I even if I knew, I probably wouldn't say too much because they'll just change the law to make it harder to convict.
Yeah. Well, yeah, and you say that we were talking about that when we were talking about DWIs a few minutes ago. It has gotten a lot harder for defendants in recent years when we do things like, first we started with the breathalyzer and the video room. Remember the videos we used to have in the video room? And
I think I practiced before there were videos.
And that was my point. We used to try DWIs without breath, without blood, so often without videos. We would, just have the cop in there saying, "Yeah, the guy smelled like alcohol and he was drunk and sloppy," and the jury could make their call.
Failed the horizontal gaze and the nystagmus.
All of that. We have a lot more prosecutorial tools in our toolbox.
You think the jury follows that very closely? I'm just joking. That's
don't
when you
know.
follow the pen.
Right, horizontal
like that.
gaze and nystagmus.
Yeah, again, I don't want to reveal too many secrets because they'll just change up the laws and people know what to do. But horizontal gaze, I don't think there's a great deal of credibility with that test. That would be my opinion generally.
Yeah. Physiologists would argue with you about that.
Right.
But in any,
Look, I wear contacts. I got a big nose. I can't.
and I said there are things that can affect it. You know, certain medications, certain health conditions, and there are lots of things that can affect that.
So so you try it. So there's a lot of DWIs being tried, and of course, there's the blood test. They started taking blood tests. When did that come into force?
I don't know, like maybe
2 years ago.
Yeah, 3 or 4 or something like that. I don't remember
Time
exactly.
flies when you're having fun. I like to say.
Yes.
Practice is so much fun.
Well, I mean, it is kind of a big deal because that means they have to have a magistrate on call 24/7.
So why do they do this? Are blood tests more accurate than breath tests?
All the breath test does is give you an estimate of the amount of alcohol in your blood, whereas the blood test tells you exactly how much alcohol is in your blood.
You think so?
Yeah, that's
really-
science.
They don't really test the blood.
Yeah, they do.
They test the air above the blood.
Well, yes and no. The way they do that. Okay. Am I giving away trade secrets here? No,
We're just talking.
Yeah, no, you're right. They actually test the air above the blood, but that is right from, I don't know, I'm trying to figure out how to put this. It's right from the blood as opposed to having been through your lungs, through your nasal cavities, all of that. Does that make sense? It's coming right
That's
from
what
the
you're
blood.
arguing.
Yeah.
I'd argue something else.
Oh,
We're
okay,
just
well.
teasing. Okay, I'm just teasing. So,
Yeah, in other words, you're getting it closer to the source.
I tell you, okay, that's interesting too. Now I'll know.
I guess
We
that's the
try
best way
this
to put
case
it.
in a year. I'm just joking, but I personally, and this isn't to give you a hard time, I personally don't really feel very comfortable. I say, what are we, vampires now? We're taking people's blood. I think it's a kind of an invasion of privacy. I say, what do they do with this blood? Are we how long do we store this blood? I don't personally like it as a kind of an invasion of privacy or whatever. I think it's awful, but that's kind of an editorial comment.
No, I understand that, but that's why we have warrants. The police don't get to say, you know what, I think you're drunk. Come on, we're taking you to the hospital for a blood draw. They have to go to a court, a judge, and say, Judge, here's why I think I should be able to draw blood from this person. Here's the facts that support my suspicions, and if the judge agrees, then the judge will sign a warrant, and then that's where you go to the hospital and get a blood draw.
Okay, so they got a form. They got this form. Here, and then they just sign off on it, right? It's not really like a warrant that's drawn up. They just got a form.
Actually, I think the way they usually do it is they talk to the judge, by phone. Say, Judge, here's what we have. They don't actually take the person before the judge. They talk to the judge by phone and say, Judge, here's what we've got. Now, I guess they can take the person before the judge, but usually I think it's done by phone.
Yeah, I think so. But I'm just saying, it sounds like a big deal to get a warrant. Where in the warrant's basically like a form by somebody on call, and then it could be easily.
And that's just up to the judge. I mean, some judges, I think, are going to quiz the officer. Well, what about this? What about that? And you're right. There are probably some judges who do say, "Oh, okay, it sounds like you got it," and sign it without questioning it much. And that's going to go from judge to judge. And I would hope the judges take it seriously. And in my experience, they do. I mean, you always hear the stories, that come out when people challenge warrants about why the judge didn't take it seriously or why the cop lied to the judge or, all these kinds of reasons why the warrant should be invalid. But I can tell you all the judges I know take warrants very seriously.
But that's good.
And they don't sign them without giving it a good deal of thought and asking the officers some questions.
So you're out driving around and you're drunk and you get in an accident. Generally speaking, does the district attorney's office look at that more seriously than if there's no accident?
Sure.
Okay. And the plea bargain may be a little bit stiffer.
Oh, yeah.
So, and then I'm driving around and I get in an accident and I don't have insurance. Do you look at that more seriously too?
No, that's for the civil lawyers to sort out.
Oh, is that right?
Other than you'll
But you
probably get a
order-
ticket for not having insurance, but
But you order restitution as part of probation, that you pay back the money. If you
frequently,
have insurance,
yes.
right?
Yes. Although I think the way it works is if you're out driving, you have an accident, you cause somebody injury or damage to their property, you make a plea bargain for probation, and restitution is part of it. Now, you get a credit against insurance. Does that make sense? In other words, you don't get to double dip,
Right, of course.
or the victim doesn't get to
Right,
double
now
dip.
that seems to be fair. In other words, the person who caused the accident in the DWI would just have to pay the deductible, maybe a $250 deductible. They don't have to, because they had insurance. They don't have to pay for the
Right.
damages.
In other words, if you've got medical bills of $5,000, but you're actually only out $500 because insurance paid the rest,
Right.
then typically the restitution will be the $500.
Even if it's just your insurance,
Yes.
whether it's the insurance company of the person who got hit or the person who caused the DWI, you would only be entitled to the person who got hit by the drunken driver would only be entitled to the deductible. Does the insurance company for the
What I call it is you're entitled to your out of pocket,
Right.
whatever it actually costs you,
right?
which is kind of I don't know. I'm not sure that's really logically correct, because what's going to happen? Your insurance rates are going to go up. That's going to cost you out of pocket. There's a lot of sort of secondary out of pocket costs. And sometimes the insurance companies do get involved, and we'll get a letter from them saying, please, basically protect our interests in this. We've had to pay out the $5,000 and we want it back.
They want their money.
And when we get letters like that, then we do our best to honor that.
I see. So they take your blood, they put it in this vial, right?
Right.
And then I
They-
guess a police officer keeps it.
Well, first there's some chemicals that are already in the vial to stabilize the blood, to keep it.
That's where the
keep it-
contamination.
keep
That's
it-
why the test
no,
is inaccurate.
keeps it
Because
from-
of the chemical. I'm just teasing.
That's between you and the chemist. But it's
I-
supposed
I
to keep
know.
the blood from coagulating. and-
Qualifies you. I'm just teasing. I'm interrupting you.
But then, yes, the officer keeps the blood, and it's called chain of custody. I'm sure as a lawyer you are familiar with that concept. It starts with the hands of the
Chain of
person.
custody's never good. Just joking.
The person drawing the blood takes the blood, puts it in the vial, hands it to the officer, who packages it up, puts it in a little envelope or box, seals it, and then it is taken by either that officer or by another officer to the DPS lab, where the seal is broken, the blood is analyzed, it's resealed. Then an officer brings it back to CCPD or whatever other agency is handling that case. So it's available there in court when we're ready for it.
There was a big, I think Texas Department of Public Safety scandal. How many years ago was that regarding contamination? And they fired someone. And I think there's been a couple scandals like that. Are you familiar with those?
There have been some scandals like that. I don't
we
remember
had
it being DPS though. There was a police lab in Houston.
Is that where that was?
Yeah, HPD actually had their own lab, and there was some kind of a scandal there, and I think a lot of convictions got thrown out because of it, and probably some people did get fired, maybe even prosecuted. And that's happened in other places too. I'm familiar with the one in Houston just because I see it in the news.
I'm not going to ask you. But regarding whether or not a judge who is not a citizen, who has been sitting as a judge, regarding whether or not those convictions are going to be thrown out. But that's a topical issue right now.
Well, I'll tell you what, I don't mind getting on the soapbox there. She's a friend of mine, and I think she's a good person. She's a good judge, a good lawyer. And, nobody ever asked her about her citizenship. She's here legally. She's doing everything she's supposed to do. That wasn't a question on her application for city employment.
Interesting.
And, I think the question was, are you eligible to hold government jobs? And she said, yes, I am, which she is.
Well, if the question was never asked, I didn't know, in all honesty, I thought you had to be a United States citizen to be a lawyer.
No.
I don't remember that.
No, you don't.
You know how many years ago this has been,
Sure.
right?
Actually, you don't.
Unfortunately.
I mean, obviously you have to be here legally, but I don't believe you have to be. I mean, she's a licensed lawyer. The person we're talking about is a citizen of South Korea. She's never
Well, I've been in that court. I haven't had any problems with that judge either. I was just, I just broached it kind of out of humor, because again, we're just talking.
Yeah, that whole thing kind of annoys me, the way she's being treated, because I don't think she's being treated fairly. She hasn't done anything wrong, and she hasn't misrepresented anything to anybody.
Well, you're right. I mean, you only state what you're asked, right?
Right.
On any of these application forms, I assume.
Well, and I'm assuming, and knowing her, I feel sure this is true. If they'd said, "Are you a United States citizen?" she would have said, "No, I'm not. I'm a citizen of South Korea."
Well, I think the issue came up is for that position, you are supposed to be a licensed voter in Nueces County. And she's not a licensed voter because she's not a citizen.
Right.
Therefore, she doesn't qualify. Having said that, maybe she didn't know that, and she wasn't asked.
I don't think that was a question asked. Though.
I don't know.
No, I think the question was, are you eligible to hold government employment positions? I mean, I may be wrong, but
no, that could very well be correct. And I'm not beating up on anyone either. It's just a topical issue. One interesting thing I found. Did you ever, when you were in private practice, you ever go out to some little town somewhere and you got a case, and I think it's the county court judge isn't a lawyer? Have you seen that before?
I have run into that.
Yeah.
Usually, it's at the JP court level where they're not required to be lawyers.
I think some of the county courts too. I think.
You may be right.
I think, and then I shouldn't laugh, but then sometimes they don't know what you're talking about.
Yeah, no, I understand.
You know what I'm saying? I'm only bringing that up because of that other issue. So that's the deal on DWIs. Obviously, they got the blood test now, and do they still do the breath tests at all?
Sure.
Do they do them both?
Yeah, in fact, there's a new the Intoxilizer 5000 that we're all familiar with is being replaced by a new model. We just had a little seminar on this, as a matter of fact. I think it's called the Intoxilizer 9000, if I'm not mistaken, and this is the new and improved model. But yeah, they still do breath tests. I still prefer blood because I just think, as we discussed a few minutes ago, strictly speaking, you're right. We're testing the gas on top of the blood, but the gas is coming straight from the blood as opposed to having been processed through the body. I guess that's the words I was looking for earlier.
Interesting. So they got a brand new model, huh?
Yeah, I think it is the 9000.
And that's in the police station, right?
That's a good question. I don't know if we actually have that here or not yet. That's a good question. I don't know.
Well, I mean, we used to have the videos all the time. I don't see them as much. They had a video, and they asked them to feel and then would you like to blow in the machine? And
well, now the videos we get now are mostly from the field.
Right.
The cars all have cameras, and now for the most part, the officers all have body-mounted cameras. And that's the videos we're getting.
How do you like looking through those videos? Isn't that great? I'm just teasing. Years ago, we'd look at the police reports and say that 5 minutes. Now we got the
sometimes several hours. Yeah.
We got these hours of videos to look at, right?
Yes, and a lot of it is like there's in the car. There's one camera that looks out the windshield, and there's another one that looks into the back seat, and a lot of it is just the guy sitting there. Being transported from the arrest scene down to get booked, and you got to but you never know when he might say something, so you got to watch the whole thing.
Let me ask you, how many, like on an average DWI trial, how many of those videos are actually shown to the jury? How much of the video is actually shown?
It depends. We usually will show the field videos of where they do the standard field sobriety test, where they have to walk the line and do the other the one leg stand and all that. If we've got a half an hour of the guy just being transported around in police cars, we don't usually show that to the jury unless something happens that's noteworthy.
I see. Well, I'm getting old enough. I'm going to do it. Like if God forbid something like that happened to me, I'll use the old defense. I'm too old to walk the straight line. I can't stand on one leg. I can't. I'm too old.
Well, there's a lot of rules about that, about how that can be administered. It's got to be on level ground. It's got to be no gravel or other debris. What kind of shoes do you have on? And then some of the questions the officers will ask: have you had any head injuries? Are you on any medications? And
yeah, do you try many of the DWI cases wherein the defendant isn't on an illegal drug, but is on like a legal drug and is intoxicated, or do you usually kind of give those cases?
No, I mean, it's still a pretty low percentage,
Right.
but we do see those. People, you see them in the field with doing the test and talking to the officer, and it's very obvious they're intoxicated on something. And they do a blood draw or a breath test, and there's zero alcohol in their systems. Well, something else is going on, and if there's no health conditions, and sometimes they'll helpfully have like a bottle of Xanax or something right there in their pocket.
Helpfully for who? Not for them. Helpfully for you. But then do they often do a blood test, and can they determine Xanax in the system?
Yes.
They can.
Yes, and we don't routinely check. I mean, usually when we do a blood draw, it's for alcohol. There is sort of a second level of testing that can be done that has to be specifically requested on a case per case basis, where they do a panel of commonly abused drugs, which is the benzodiazepams like Xanax, or the opiates, which would be like heroin, that kind of stuff, or for the amphetamines.
What about testing for marijuana?
That's in there too.
And is it called THC? I've forgotten.
THC,
THC
yes.
level, which indicates
Tetrahydra something.
Yeah, that indicates intoxication. It's 0.08 or over blood alcohol, but it's not. There's no standard for.
No, there are equivalents.
Marijuana.
If you talk to blood chemists, they'll tell you the equivalent for THC to get to 0.08 on alcohol. The THC equivalent of that is this value, or the opiate equivalent of that is this value. But that's not carved into law like the 0.08 for alcohol is.
Right. Maybe someday they'll do that.
Well, they probably should.
Because now, with the possible, I guess marijuana has primarily been decriminalized. They said that in McGovern, 1972. We're going to decriminalize marijuana. It's largely been decriminalized.
Some places.
In most parts of Texas, I think, right? Minor amounts of marijuana.
Oh, minor amounts. Well, not really decriminalized so much as just being handled in the system differently.
Yes.
I mean, it's still illegal. I mean, other than for certain medical cases, it is still illegal in Texas to, possess any amount of marijuana.
Certainly.
Now, what's going to happen to you if you get caught possessing it? Is it different from how it was, 5, 10, 15 years ago? Sure.
And what do you think about legalization of marijuana? Do you think if they legalize marijuana, you're going to have a lot more people high on marijuana driving?
I think it'd be a problem. I mean, I think there's both good and bad to that possibility. I mean, I think the pharmaceutical implications of it, you hear about the things that medical marijuana can do, and I really think that needs to be explored, because I think they could, if they try to do it, I think they could probably create some wonder drugs out of that stuff. But as you say, if it's legal to possess it, yeah, people are going to get high and drive, and that's kind of a problem.
Well, I've heard that that's a problem anecdotally on people that I know been to California, to Colorado.
Yeah.
That there's a lot more people driving stoned, or a lot more of the waiters and waitresses are apparently stoned.
Wouldn't surprise me. I can tell you, my family took a little trip to Colorado in February. Mm-hmm. And in fact, I brought some of these back right there in the hotel lobby, where they have those little racks of brochures for things to do. And there were brochures for marijuana tourism in Colorado. I actually brought those back to show people. It I'd never seen anything like that. It just floored me.
I go back, I don't know about you personally, but I go back and forth on the issue. I thought they need to legalize all drugs. They need to legalize them all and then take care of it as a health problem. And then these states have had have had these other countries have had such success with it. Then I say, well, no, now that they're doing it, legalizing marijuana here, I get a little scared. I don't know. Maybe it's not such a good idea. I don't know. Because I knew a lot of people. I'm of the generation where most of the kids smoked, right? Most of them. I would say in my, at least of a certain social class. And a lot of them got addicted, I thought, and kept smoking the next 30 years. So I don't know.
Yeah, I think the scientific evidence is kind of muddled on whether there is such thing as a true
absolutely
marijuana addiction.
Yes.
The I understand what you're saying, and I think there are a lot of arguments both for and against legalization. Right. To me, the biggest one for it is the problem with synthetic marijuana.
That's what all the assistant DAs are telling me.
Yeah, that stuff is hideous. It really is. And what it does to people is frightening. And I can't help but wonder what would happen to synthetic marijuana if we legalized the real thing. I think the synthetic marijuana problem would pretty much go away overnight. And to me, that's the biggest argument for legalization. Now, there's plenty
But is it a comparable... I don't think it's even I don't know. They call it synthetic marijuana and it's smoked, but I don't think it's a comparable what you would term as high anyway. So I'm not certain it wouldn't just duplicate the problem. I don't know.
And you may be right. You may be right.
So I don't know.
And that's part of the problem with that synthetic is, and you're right, it's not really, there's no component of that that's actually marijuana. You're right. It's usually, I think, what we used to call potpourri with a bunch of chemicals stirred in it.
Right.
And I think some of these guys that make that stuff are just going out in the garage and saying, oh, I got some transmission fluid and some bug spray and some Drano. Let's just stir this up and see what happens.
Well, that's what you think. Have you ever been able to trace it? Have you ever seen where they're making it? Or we don't know?
I haven't. I don't know.
It may have came up in one of the cases or something.
Yeah.
This guy's because remember when there was a lot of buzz for, was it crystal meth or
yeah, the crystal meth and ice
the
and all that.
Laboratories, yeah. But I haven't seen really the laboratories for the synthetic marijuana busted so much.
Yeah, that's a good point. And I think maybe the answer is just what I said. A lot of guys are just stirring that stuff up in their garage and putting God only knows what in it.
So what's the difference between a criminal case in a district court versus a criminal case in a county court here? Misdemeanors in obviously county court and felonies in district court. Is there any other differences? The way they're tried or anything?
Well, in misdemeanor court, you try cases to juries of 6 instead of juries of 12. But other than that, no, it's really, it's the same rules of evidence and procedure.
Yeah, so some years ago, I've always thought all the criminal cases were the same, really. Even a big one. I said, well, what difference does it make? It's all the same.
Well, the stakes are a lot lower in misdemeanor court, obviously.
Right. Do you think a jury of 12 acts differently than a jury of 6?
I don't know. That's a good question. Never really thought much about it. From the prosecutor's standpoint, I guess I only have to convince 6 of them instead of 12.
I always thought a jury of 6 is more likely to think as one body, and a jury of 12 is a lot less likely to.
Well, you're going to have, obviously, just by numbers, you're going to have... By numbers. You're not going to have so many differing opinions.
And factions are less likely. That was my impression, but I haven't... tried a misdemeanor case.
Well, if you take a set of 12 people and a set of 6 people, that one guy who's going to hang any jury that he sits on, who just can't be with the others.
Yes, you're looking for. We're trying to get off of there. I'm just teasing.
No, that's the one you defense lawyers want that guy on the jury.
No, you. I thought you were saying you want the guy that's always going to.
No, I'm just saying you're more likely, just statistically, with a group of 12 versus a group of 6, you're more likely to get one of those people.
Yeah, that's very possible. And what other kind of cases are you doing in misdemeanor court? I guess you do theft cases, and shoplifting cases are kind of interesting. I don't know if they've always been enhanced. In other words, where you could increase them the same way as DWIs to a felony status, but I know it's that way now.
Yeah, I don't know. It's been that way as long as I've been a prosecutor, and honestly, as long as I've been practicing criminal law, but I don't know exactly when that was enacted.
I don't think when I started it was done that way, but it is now.
Yeah, if you have 2 prior thefts,
right,
then any theft is or can be enhanced to a state jail felony.
And then even upwards. Even upwards, correct?
Beyond. Well, yeah. Now, if you have other types of, for instance, if you have a state jail felony theft, which is a felony because you have prior shoplifting cases, if you then have, for instance, other felony convictions where you did time for them, the possibility of it getting enhanced to above a state jail is also there. If you've been to the pen twice for robbery or murder or whatever, then yeah, we can enhance that yet again.
Repeat felony offender, habitual felony offender?
Yes.
RFO, HFO?
Yes.
Repeat felony offender is a minimum of 15 years in prison, and HFO, habitual felony, is a minimum of 25, is that correct?
No, what happens is, with repeat felony offender, it basically just moves the level of the offense up one notch. In other words, if it's a 3rd-degree felony, when you add RFO, repeat felony offender, it becomes a 2nd degree. Where you're getting the 15 minimum is for first-degree felonies, it's a minimum of 5. But if you are a repeat felony offender, it becomes a minimum of 15. And if you are a habitual felony offender, meaning 2 or more priors, then it's a minimum of 25.
You know, the guy who's I'm
Oh,
sorry.
and I was going to say now, but the habitual is different because even if you have a third-degree felony, if you've got the 2 priors, that can be straight to minimum 25.
Right.
So it's pretty complicated, and
It is. So, you get to habitual felony offender. I had one recently, and they didn't have a very strong case against my guy, but I said, hey, look, they may not have a strong case against you, but if you are found guilty, a habitual felony offender, and the way it was, the kind of case it was, whether it was aggravated or against an elderly or something, I said, well, if you're looking at going to ruin your life,
you're going to fall hard here.
Yeah. Even if it's a 1 in 10 chance, I don't know if I'm going to be taking the chance. Yeah. So the prosecution has a lot more, I think, power when it's a habitual felony offender.
And I can tell you personally, and I think most prosecutors do this, when I look at a case when I'm doing what we call intake, which is just where the agency that worked up the case brings it to us, and we look at it and decide if we're going to indict it, and if so, what offense are we going to indict and at what level. Not everybody who can be enhanced should be enhanced. In other words, we don't make somebody HFO just because we can.
I thought it was a standard procedure. I thought you always did that. No?
I don't think so. No, I certainly don't. I look at it and see what kind of a guy is this, what kind of legal history does he have.
How many years has it been since his last conviction, things like that?
The classic case is the candy bar, Is a candy bar worth somebody doing a minimum of 25 years for? Probably not, but you got to look at the facts. If the guy's got, 27 theft convictions, well, maybe he does need to take a hard fall. But you have to look at that on a case-by-case basis.
Well, and that's where, they come up with all these laws and they come up with all these specifications to screen things. But one of the things you want is if you have an honest prosecutor with some wisdom, that goes a long way, right? Versus somebody that just follows the...
Yeah, well, and that's what prosecutorial discretion is all about, and that's what our oath is to do the right thing and to seek justice, not just convictions. And I personally, and I think most prosecutors, take that very seriously. And that's why if I see somebody who maybe I can enhance him to HFO, but when I look at the facts, it just doesn't, The test I use is, well, would I feel ridiculous standing in front of a jury asking for a 25-year minimum for what this guy has done? Does that seem ridiculous or unfair or unjust under this circumstances? And if the answer is yeah, it does, then I don't enhance that guy.
So we're reaching the end of our show. Let me tell you, I was telling someone, a young lawyer was telling me he was in a town and his client got a big sentence, and it was a conservative town, and his defendant had tattoos on his face. I was going to tell young people, be careful about putting tattoos on your face. You may find some discrimination in the average jury.
Yeah, and you are going to run into that. There are people who don't like tattoos. I try to judge people on
their merits or
what they do rather than on what they look like. But yeah, you're going to run into that, I'm sure.
Discrimination. Mr. Gordon, thank you very much for coming on the show.
Well, thank you for having me.
Talking to you, and longtime prosecutor, 11 years in Oasis County. Thank you for watching. Good night.